Hello guys and welcome to the LawPutra's YouTube channel. I am Jagannath Kulkarni and today's our topic of discussion is doctrinal research and non-doctrinal research. Since this is the law channel, we will definitely talk about the research, that is the legal research. Let us see what it is. Doctrinal research and non-doctrinal research, these are the two prominent methodologies which we employ while we conduct the legal research. So this is the basic thing. Research, if we see the word, the original French word is rechercher, which means to investigate thoroughly. And when it comes to the legal research, it should dive deeper into the legal ocean. And we know how big the legal ocean is. We have to search and research what? The laws, their origin, their application, and ultimately everything else that can have the slightest nexus with the legal sphere. So everything we have to search and research. And we need to try to research and analyze the effect of all legal variables, non-legal variables on the process of legal decision making. So how the legal decisions have been made, we need to go to the roots of that legal decision. And this is the basic purpose of this legal research. And while we apply these two doctrines, these two methods, doctrinal methods and non-doctrinal methods, let us see what are they. Let us first discuss about the doctrinal research. It says, obviously, the doctrinal word comes from the word original doctrine. And the doctrine word has come from the Latin word, that is the doctrina, which means education, knowledge or learning. And basically, by doctrine we means it's some principle or some basic governing tenet. So that is the doctrine. And most common methodology, this is the doctrinal research, is the most common method, very primary method, and it is the traditional method as well. Let us see how and why. It asks the questions, what is the law in a particular case? So it will always talk about the theory of that research. And it concerned with the analysis of legal doctrine, how it was developed and applied. So that needs to be checked. It is purely theoretical research. It doesn't consider the practical aspects of the case. It considers only what the law behind it and what is the theory behind it. So this is the doctrinal research. And it is a simple research. It will just aim at finding a specific statement of law, and legal analysis with more complex logic, depth, both way it can be done. Either it can be simple or it can be the complex. But the basic thing is that it only considers the law, it only considers the theory. It is the research which is carried out on a legal proposition, maybe a single proposition or maybe multiple propositions. And by way of analyzing the existing statutory provisions and cases by applying the reasoning power. Why such case might have been decided in this way? So we have to apply the reasoning power. It is basically checking the validity of existing laws in the light of changing society. The laws have been made in the past and they have been applied in the present, and we need to have the dynamic society, changing society. We need to see the application of it. It begins with one or more legal propositions taken as a starting point. Then entire research is directed in finding the validity of that hypothesis. Hypothesis is the assumption, presumption that we know, we have learnt it in the school days. And reviewing and studying the different legal documents, other sources, and then deducing a complete answer to question which is asked at the beginning by means of rational interpretation and logical reasoning. So these two basic things we need to bear in mind. And most often the starting point in any research is the doctrinal research. That's why it is the library based, we also call it armchair, and then it move forward to other methodologies once our base is set by doctrinal research. So we need to set the base with this doctrinal research because it's the basic, it is the primary, it is the fundamental. And then it is very famous among students and academicians because obviously without any practical approach, without any practical experience, obviously anyone would start with the library, anyone would start with the what is existing already there in the theory. Now see what is the non-doctrinal research. It is the social legal research. Always remember in mind, it is the practical social research, what is actually happening in the society. It employs the methods taken from other disciplines to generate empirical data which answer the research questions. Whatever research question we are bearing in mind, and multidisciplinary approach towards legal research. This is very important. It doesn't stick itself to the law. It takes the other approaches also, and this employs the methods and information available from other disciplines to make a comprehensive approach towards the law. Law we cannot see in the isolation. Remember, employs primary sources, observations, experiments, questionnaires, surveys, etc. of legal information to reach a conclusion. So this is important. Very first-hand information we are taking. We are not taking any second-hand information. All the primary sources are available, and that we are exploring. Analyze practical aspects of law. Effect of its implementation in non-legal fields. Law is not required only in legal fields. Even in the non-legal fields we need to apply the law. And of course the society as a whole. Because the very purpose of law is for the society, benefit of society. And basically we take a legal variable which could be a law along with a non-legal variable, say economic, social, political, etc. And then we study their relationship by data collection. And this data can be qualitative or quantitative, depends on the researcher, depends on the research methodology, and how the law works in the real world. That is very important. Okay, law, the legislature have enacted the law. How it actually works in the real world, that is very important. Also, after how it started, after the Second World War, there was a growing emphasis on empiricism, and a realist school of thought developed because of this. Empiricism is important. Whatever is happening in theory, that is okay, but what's the practice is? It brings to forefront the concern that laws are made for benefit and regulation of society. Okay, society is not meant for law. Law is meant for society. And laws are there to fulfill society's needs. They cannot be studied in isolation. They must be developed as per the dynamic society's requirements. Society is changing, dynamic. It can't be static. And therefore the laws also should be suited to needs of real world. And then developed out of growing need of bringing the law for the realism, today's realism. Also, this is the legal research should deal more with its practical application and how it functions and affects life of people in real world. And it should deal less with the theoretical aspects of studying written law. Written law is okay, but how it is being applied, how it is being practiced, that is also important. And growing emphasis on the welfare state model. Ultimately, what is the purpose? To achieve the welfare state. And the state was meant to serve the society, and all the laws that it brings, legislature, must cater to this need of welfare of citizens. Law is not to make the life hazardous. Law is to make the life good. It should lead to the welfare state of the citizen. And governments have also encouraged this field of research, obviously, because that is the ultimate aim, to bring out the legislation which truly help people. And we can see in the changing dynamic world, the legislations that are coming day by day, they are actually truly helping the people. And to judge how well they have performed, that is also important. What is the purpose in the mind of lawmakers? Whether it is fulfilling that, that is also required to be judged. Now let us see the advantages of both. Doctrinal, it is forms the base of legal research in academic field of law. The law students at graduate, postgraduate level, they usually venture into world of legal research with help of this methodology, doctrinal, because that is the starting point for them, where they can analyze sources available in library, and then they logically deduce the findings. And because they are not well equipped at this particular stage to get involved with empirical research, and so they will believe in the doctrinal research. So they will study the law as it is. That's a good starting point. If we see the non-doctrinal, its utility in practical purposes. It helps in gauging the practical effectiveness of laws in various non-legal fields. And it is an effective tool to judge the performance of law in the society. So these are the comparative advantages. Also, this doctrinal research gives the judges and lawyers flexibility to approach law from different aspects and make it interpretation. Judges, they are interpreting the laws. The amorphous mass of present-day statutory provisions takes concrete shape and form in great laboratories of law courts. So law courts are always looked as the laboratories of law. And the judges have over time, they have developed the law from their deep knowledge and investigation into field. And that's why we call it as the judge-made law. And the classic example is the law of torts. Doctrinal research help in development of legal research by giving it a base. And close companion of law academicians, students, judges, advocates, jurists. Now see what is the non-doctrinal. Legal issues are better analyzed when they are studied in a comprehensive manner by taking into consideration all the factors that might affect it. When data is quantified, it becomes rationally more appealing and authentic since it relies on primary source of information. Also, let us see disadvantages. Doctrinal, in case of doctrinal, availability and choice of right and reliable sources. Of course, it depends on the depth of the researcher. Logical deduction is again a field task. Then highly theoretical, restricted, which is without right direction, it may become highly objective, too mechanical, very less practical aspects. It studies law individually, does not consider in the backdrop of society, which is playground of law. And without studying its normative practical aspects, it's like studying law in darkness. It seems incomplete. Obviously, law should be seen in the light of society. Non-doctrinal is time consuming and it requires a lot of time, resources, availability of funds, that is the big challenge. Then collection of data can be daunting task, obviously. Collecting right pool of information from society, again that depends on the prudence of the researcher. People have different understanding, biases, amount of information, then information collected through questionnaire surveys, they can be skewed, misleading. People are reluctant to give information. Again, collecting primary data about some can be dangerous, sensitive. If the matter is sensitive, then again it is a dangerous task for researcher and may also be blurred by researchers' own biases, prejudices. That is also possible. Now, if we compare, doctrinal is more inclined toward theoretical aspects, non-doctrinal more practical. And doctrinal is carried out on a legal proposition by way of analyzing existing statutory provisions cases by applying reasoning power. While this non-doctrinal, it is the interdisciplinary approach to observation. Doctrinal is also called as library research, armchair research, no field work, but this is the empirical research. And if we see more thing, it is theoretical, it is more practical, it is analytical or positivist doctrinal. But this is the realist school, non-doctrinal. Doctrinal is based on secondary sources, articles, commentaries, textbooks, journals, law journals, etc. But this non-doctrinal is on primary sources, surveys, case studies, so it is more useful. Doctrinal is library-based armchair, we have already seen, no field work, but this non-doctrinal, it involves the field work. Also, doctrinal, remember this thing. Doctrinal is law in books, non-doctrinal is law in action. Doctrinal is concerned with legal propositions and non-doctrinal is concerned with social values and people. So we discussed today this doctrinal research and non-doctrinal research. Just simple, doctrinal is in law. Doctrinal research, we can say it is the research in law and non-doctrinal research is about the law. Remember, research is the repeated search. Thank you. Thank you very much.